Chapter 14, Assaults. Section 230. Definition, gist of the offense. A criminal assault is an unlawful attempt to commit a physical injury upon another, or unlawfully putting another in fear of personal violence. In other words, it is an unlawful inchoate violence to the person of another with the present ability, either real or reasonably apparent, of carrying it into effect. Among other definitions by standard authorities are the following: assault is an attempt or offer with force and violence to do a corporal hurt to another. It is an attempt or offer to beat another without touching him. An assault is an apparent attempt, by violence, to do corporal hurt to another. An assault is an unlawful physical force, partly or fully put in motion, creating a reasonable apprehension of immediate physical injury to a human being. The essence or gist of assault is the intention to do harm. Section 231. An apparent intention sufficient. Under the early English rule, an actual intention to carry out the threatened harm was essential. In this country some courts have followed this rule, while others have repudiated it. The true view is that a reasonably apparent intention is sufficient. Thus, when a person points an unloaded gun at another, or threatens him with a club or other weapon, and thereby puts him in fear and causes him to retreat, or act on the defensive, he commits an assault irrespective of his actual intent. There is no assault if the intention is to aid the person who is claimed to have been assaulted. To constitute an indictable assault, however, the overt act must be accompanied with an intent, either express or implied, to do harm to another. But when the injury threatened would be the natural consequence of the overt act, the unlawful intent will be presumed. In the aggravated assaults, however, in which the gist of the offense is the specific intent, the presumption is not conclusive. Section 232. An apparent ability sufficient. It has been held, both in England and in this country, that an actual ability to carry out the threatened violence is an essential element of assault. This view, however, has been repudiated by some courts, both in England and in this country. The true view is that a reasonably apparent present ability is sufficient. The reason is that such a condition, accompanied by the threatened violence, tends directly to cause a breach of the public peace. It is well settled that any act, not excusable or justifiable, which tends directly to cause a breach of the public peace, is indictable. In some states, however, including Illinois, an actual present ability is required by statute. Section 233. Mere words or gestures insufficient. According to the ancient common law, even words might constitute an assault. This view, however, long since passed away. Nor can mere words, howsoever abusive, constitute a sufficient provocation to excuse an assault and battery. It has been held that any threatening gesture, manifesting in itself, or by words accompanying it, an immediate intention coupled with ability to commit a battery, constitutes an assault. There must be, however, violence actually offered, and within such distance that harm may follow it if the would-be assailant be not hindered. When an act is done with intent to commit an assault, but the intent is voluntarily abandoned, or the would-be assailant is prevented from carrying it into effect, while the distance between the parties is too great to commit a battery, no assault is committed. On the other hand, it has been held that, where a person approaches another with gesticulations and menaces, but not with the intention of doing him harm, it is not an assault. A mere insulting gesture does not constitute an assault. Thus, where a man makes a kissing sign at a woman by puckering up his lips and smacking them, without manifesting any intent to lay hands on her or kiss her without her consent, he is not guilty of assault. Section 234. Mere preparation insufficient. Mere preparation to commit a battery does not constitute an assault. Thus, picking up a stone 20 yards from the would-be victim, without offering or attempting to throw it, does not constitute an assault. Nor does drawing a weapon without presenting it constitute an assault. If, however, it be presented, an assault will be committed. Where several persons, with a gun, pitchfork and other weapons, follow a person, who is where he has a right to be, and by using threatening and insulting language put him in fear and thereby cause him to go home sooner than he intended to go, and by a different route, they are guilty of assault. Section 235. Menacing acts accompanied by conditional threats. To constitute an act an assault, it must be accompanied by reasonably apparent intention to injure. It follows, therefore, that menacing acts accompanied by words manifesting a contrary intent do not constitute an assault. Where a man angrily raises his cane within striking distance of another, shakes it at him and remarks that, "If you were not an old man I would knock you down," he is not guilty of assault. And where a man angrily raises his hand within striking distance of another and says, "If it were not for your grey hairs I would tear your heart out," no assault is committed. Again, where a man lays his hand on his sword and says to another, "If it were not assize time, I would not take such language from you," he does not commit an assault. Section 236. Classification of assaults. Distinguishing feature. Assaults are classified as simple assaults and aggravated assaults. At common law, The distinguishing feature of these two classes of assault lies in the nature of the criminal intent involved. In a simple assault, a general criminal intent is sufficient. This intent may be inferred from the act. Moreover, it is not essential that it be alleged in the pleadings. On the other hand, an aggravated assault involves a specific criminal intent. Moreover, it must be alleged in the pleadings and proved. And the penalty for an aggravated assault is, of course, greater than that for a simple assault. At common law, however, both classes of assault are only misdemeanors, but in many states aggravated assaults are made felonies by statute. Section 237. The aggravated assaults. The chief aggravated assaults are the following: 1. Assault with intent to murder. 2. Assault with intent to kill. 3. Assault with intent to rob. 4. Assault with intent to commit rape. 5. Assault with intent to do grievous bodily harm. And 6. Assault with a deadly weapon. Section 238. Assault with intent to murder. This offense involves the following two distinct elements: 1. A specific intent to murder. 2. An assault or attempt to carry the intent into execution. Since the gist of this offense is the specific intent to murder, this intent must be alleged in the indictment. It is also essential that the malicious intent involved in this crime be proved. This may be done, however, by circumstantial evidence. Thus, it may be inferred from the use of a deadly weapon, or from the character of the assault and other attending circumstances. Ordinarily, this offense is committed by the use of a deadly weapon. It may, however, be committed without the use of such a weapon. Section 239. Adaptation of act done and means employed to accomplish purpose. To constitute an assault with intent to murder, the act done and the means employed must be adapted to accomplish the end sought. It is not essential that the adaptation be real. It need only be apparent, because the evil to be corrected relates to apparent danger, rather than to actual injury sustained. If it be evident to every reasonable mind that the means used are entirely inadequate to the consummation of the intent charged, that fact will rebut or disprove the felonious intent, and a conviction cannot be justified. Where the object is not accomplished because of an impediment which is of such a nature as to be wholly unknown to the offender, who uses appropriate means, though not fully or only apparently adapted to the object, the criminal attempt is committed. Hence, under an indictment for assault with intent to murder, if the proof show that the accused pointed a loaded gun at another and snapped it several times, but there was no cap on it, and the court charged the jury that the absence of the cap will not avail the accused if he believed at the time that it was on the gun, but the jury must be satisfied beyond all reasonable doubt that he did not know there was no cap on the gun, a conviction will be sustained. It has been often held that to constitute this offense, a specific intent to kill must be proved. It also has been held that the means employed must be actually adapted to accomplish the end sought. This view, however, is erroneous. It is not essential to constitute an assault, or an assault and battery, with intent to commit a felony, that the intent and the present ability to execute be conjoined. Section 240. Proof that death of victim would have been murder essential, but not sufficient. To constitute assault with intent to murder, the proof must show that had the victim died the crime would have been murder. On the other hand, proof that had the victim died the crime would have been murder is not of itself sufficient proof of assault with intent to murder. This is owing to the fact that murder involves only a general criminal intent and not necessarily a specific intent to kill. Section 241. Assault with intent to commit manslaughter. Is there such a crime as assault with intent to commit manslaughter? Upon this point the decisions are not harmonious. In Iowa the question has been answered in the affirmative, and it is held that if an unlawful assault was made upon reasonable provocation in the heat of blood, but without malice, and without legal excuse, and with intent to kill, then the defendant would be guilty of an assault with intent to commit manslaughter. On the other hand, the courts of some states, including those of Illinois and Michigan, hold the contrary view. It is said that if there was an intent to take life and the killing would not be excusable or justifiable, it would be assault with intent to commit murder, that a specific intent cannot be found to exist in the absence of reflection and deliberation. The latter view is correct upon principle and supported by the weight of authority. Section 242. Assault with intent to kill. This offense differs from assault with intent to murder in the intent involved. In the case of intent to murder the proof must be such as shows that, if death had been caused by the assault, the assailant would have been guilty of murder, and in the case of assault with intent to kill the proof need only be such as that, had death ensued, the crime would have been manslaughter. In the former case the intent must be the result of malice aforethought, and in the latter, the result of sudden passion or emotion without time for deliberation or reflection. A conviction of assault with intent to kill may be proper though the wounds actually inflicted were not such as would be usually fatal. On the other hand, the test whether a conviction of assault with intent to murder should be sustained is not whether the accused inflicted a wound likely to produce death, but whether the assault was of a character likely to be attended with dangerous consequences and of a nature to cause death, in which case malicious intent will be presumed. Section 243. Assault with intent to rob. To constitute assault with intent to rob, the act must be done with the specific intent to take from the person of another, or from his presence, his personal property, by violence or putting him in fear. If the intent be to take his property by stealth, and not by violence or putting in fear, the crime of assault with intent to rob will not be committed. Section 244. Assault with intent to commit rape. To constitute assault with intent to commit rape, the act must be accompanied with a specific intent to have carnal knowledge of the woman without her consent and by the use of such force as should be sufficient to overcome such resistance as she should make. On the other hand, if the proofs show that the intent of the accused was to have carnal knowledge of the woman, but without force, and not against her consent, it will fall short of proving him guilty of assault with intent to commit rape. The foregoing propositions are not applicable, of course, when the female is under the age of consent. When the evidence shows that the accused intended forcibly to have carnal knowledge of the woman and his efforts failed owing to his inability to overcome her resistance, or from fear, a conviction will be sustained. Some courts hold that actual violence is essential to constitute this offense. Others hold the contrary. The latter hold that the specific intent to commit rape, preparations to carry out this intent and present ability to accomplish it, are sufficient. It also has been held that impotency is not a defense to a charge of assault with intent to commit rape. Section 245. Transferability of the criminal intent. It has been held that the specific criminal intent involved in an aggravated assault is not transferable. Thus, it has been held that where one aiming at A misses him and wounds B, he cannot be convicted of assault with intent to kill B. This view, however, is not correct upon principle, nor is it in accord with the weight of authority. Where a person deliberately shoots at A, and in the direction of B, and the ball misses A and strikes B, inflicting a wound, these facts will show sufficiently the intention of the person shooting to kill and murder B, although he has no actual malice or ill feeling toward B, and he may be convicted of an assault upon B with intent to murder him. And where one, without provocation, discharges a gun directly at a group of persons, it is immaterial what person he intended to kill, or if, under such circumstances, he shoot a person other than the one intended, the act, from its recklessness and want of provocation, will be referred to no other cause than malice. Such recklessness implies malice. The same principle is applicable where the offender is mistaken as to the identity of his victim. Thus, where A attacks B, believing him to be C, and tries to kill him, he will be guilty of assault with intent to kill. It is to be observed, however, that the courts refuse to recognize a transferability of specific criminal intent from a person to a thing, or vice versa. Thus, where one, who has been fighting, throws a stone at his adversary and it passes over the latter's head and shatters a large plate glass window, the offender is not guilty of malicious mischief. And where one shoots at another on horseback with intent to murder him, and misses the man but kills the horse, he is not guilty of maliciously killing the horse. It is also to be observed that a specific intent to commit one offense will not take the place of a specific intent to commit a different offense. Thus, where a burglar is convicted of assaulting a watchman with intent to commit murder, maim and disable him, and the proof shows that the burglar's intent was only to disable the watchman temporarily until the former could escape, the conviction will be set aside. Section 246. Assault with intent to do grievous bodily harm. In some states, statutes have been passed specifically punishing assault with intent to do grievous bodily harm. To constitute this offense, the specific intent to do grievous bodily harm is essential. It has been held, however, that general malice is sufficient, that particular malice against the person wounded is not essential, and also that it is immaterial whether grievous bodily harm is committed or not. Section 247. Assault with a deadly weapon. In most states, statutes have been passed creating this class of aggravated assault. The offense is made to depend, in part at least, upon the character of the weapon used. The statutes, however, are not uniform. Some require one specific criminal intent, others require a different one, while still others require none at all. Thus, the New York Penal Code requires that the act be done with a deadly or dangerous weapon, with an intent to kill a human being, or to commit a felony upon the person or the property of the one assaulted. The California Penal Code requires that it be likely to produce great bodily injury. Under these statutes, the gist of the offense consists in the specific intent involved as well as in the dangerous nature of the weapon used. In Texas, if the assault be made with a deadly weapon, it is ipso facto an aggravated assault irrespective of any specific criminal intent, and it is unnecessary to allege or prove the intent with which the assault was made. Upon an indictment for assault with a deadly weapon, it has been held that, where it appears that the accused held a pistol in one hand and took hold of the prosecuting witness by the throat with the other hand, but did not present the pistol, or attempt to shoot, or even threaten to do so, the offense committed is false imprisonment but not assault with a deadly weapon. From the mere fact of the use of a deadly weapon, irrespective of the circumstances under which it was used, there is no necessary presumption of malicious intent. Section 248. What is a deadly weapon? A deadly weapon is any instrument by which death may be produced, or would be likely to cause death, when used in the manner in which it may appear it was used in the particular case. It is to be observed, however, that a weapon is not necessarily a deadly weapon merely because it is capable of causing death. In some cases courts take judicial notice that certain instruments are deadly weapons. Thus, courts have held that a loaded gun, brass knuckles, a hoe, a sledgehammer, an axe, a club, a rolling pin, etc., are deadly weapons. On the other hand, when the weapon is one not likely to cause death, either from its inherent nature or from the manner in which it is used, the question whether it is a deadly weapon or not is one for the jury to decide. Thus, where the assault is made with a stick, weighty, a stone, a glass tumbler, a chain, a horseshoe, a pocket knife or a pistol used as a club, the question is one of fact for the jury. Pointing an unloaded pistol at another is not an assault with a deadly weapon. Section 249. Assault and battery. Assault and battery is a separate and distinct offense from assault. 88. Every battery, however, includes an assault, and therefore, upon an indictment for assault and battery the accused may be convicted of assault only. A battery is any unlawful touching of the person of another, either by the offender himself, or by something put in motion by him. When done in an angry, rude, insolent or revengeful manner, any touching, however slight, will constitute a battery. The law does not discriminate between different degrees of force, and therefore the slightest force is sufficient. Thus, spitting on another, in an angry, rude or insolent manner, constitutes an assault and battery. To touch another in anger, though in the slightest degree, or under pretense of passing, is an assault and battery. Even to snatch a paper from another is technically an assault and battery. Shoving another with one's open hand, upsetting a chair or carriage in which a person is sitting, throwing oil of vitriol on the person of another, or placing one's hand on another's head and pushing his hat back for the purpose of seeing his face, in order to identify him, are all batteries. The following instruction is correct and has been sustained. The court further instructs the jury that if they believed, beyond a reasonable doubt, from the evidence, that the defendant, in anger, laid his hand on Stephen Grant, or in any manner took hold of him in anger, then the defendant would be guilty of an assault and battery. Section 250. Taking indecent liberties with women. When a man takes indecent liberties with a girl or woman, by handling or fondling her, without her consent and against her will, he is guilty of assault and battery. Thus, when a man, without some innocent reason or excuse, puts his arm around the neck of another man's wife, without her consent and against her will, he is guilty of assault and battery. Section 251. Mere familiarity not a crime. Mere familiarity between a male and female, even when the latter is under the age of consent, is not a crime. Thus, mere familiarity between a man and a girl under the age of consent, who have been intimate and frequently in each other's company, consisting of the man's putting his arm around the girl's waist with her consent, does not, in the absence of any offer or threat to take, or request to be allowed to take, any other liberties with her person, constitute an assault and battery. Section 252. Consent obtained by fraud. Consent obtained by fraud is no defense. The outrage upon the woman, and the injury to society, is as great as if actual force had been employed. In this class of cases the courts discriminate between active consent and passive non-resistance. Section 253. Taking indecent liberties with children, Illinois Statute. The crime of assault and battery can be committed also by taking indecent liberties with children of either sex, and the fact that they consent to the act is no defense when ignorant of the offense committed. In some states, including Illinois, there are statutes which make the taking of indecent liberties with children a felony. Section 254. The force can be applied indirectly. To constitute an assault and battery it is not essential that the force be applied directly. It also can be applied indirectly. Section 255. Administering poison or other deleterious drugs. When a person, knowing that a certain thing contains poison or other injurious drug, gives it to another to eat, and the person receiving it, being ignorant of its hurtful nature eats it and suffers injury, the giver is guilty of assault and battery. Thus, when a man gives a girl figs, he knowing at the time that they are medicated with cantharids, and she eats them, having no reason to suspect that they contain any foreign substance, and they make her sick, he is guilty of assault and battery. In this case the court said, although force and violence are included in all definitions of assault, or assault and battery, yet where there is physical injury to another person, it is sufficient that the cause is set in motion by the defendant, or that the person is subjected to its operation by means of any act or control which the defendant exerts. If one should hand an explosive substance to another, and induce him to take it by misrepresenting or concealing its dangerous qualities, and the other, ignorant of its character, should receive it and cause it to explode in his pocket or hand, and should be injured by it, the offending party would be guilty of a battery, and that would necessarily include an assault, although he might not be guilty even of an assault, if the substance failed to explode or failed to cause any injury. It would be the same if it exploded in his mouth or stomach. If that which causes the injury is set in motion by the wrongful act of the defendant, it cannot be material whether it acts upon the personal injury externally or internally, by mechanical or chemical force. In this class of cases, the deceit, by means of which the person is induced to take the drug, is a fraud upon his will equivalent to force in overpowering it. It has been held, however, both in England and in this country, that to administer poison or other deleterious drug to a person who takes it willingly, but in ignorance of its real nature, does not constitute an assault and battery. This view, however, is erroneous and not in accord with the weight of authority. Section 256. Striking a substance attached to a person. When a person rudely or angrily strikes anything attached to another person, he commits assault and battery. Thus when one rudely or angrily strikes a cane in another's hand, the crime is committed. Section 257. Setting a dog on a person. A person may be guilty of assault and battery in setting a dog on another and causing it to bite him. Section 258. Striking another's horse. To strike another's horse attached to a carriage in which a person is riding may constitute an assault and battery. To do so, however, it is essential that the person in the carriage receives some injury. This is owing to the fact that a battery consists in personal violence. On the other hand, merely to strike another's team, even angrily, which he is driving, does not, of itself, constitute assault and battery. Section 259. Exposing a helpless person to the inclemency of the weather. Assault and battery can be committed by indirectly causing an injury to another by exposing him to the inclemency of the weather. Thus, where a person takes a helpless infant from its mother, even with her consent, telling her that he will take it to an institution to be cared for, but instead of doing so puts it in a bag and hangs it on a fence at the side of a public highway and leaves it there, and it suffers injury in consequence of inclement weather, the offender is guilty of assault and battery. Consent of the mother in such case is no defense, the court holding that since the mother gave that consent on the false pretext that the child was to be taken to some institution, and, as that pretext was false, it was really no consent to constitute an assault and battery. However, the infant must suffer an injury. Where a mother abandons her helpless babe in the public street at night, without clothes or covering, exposed to the elements and such other dangers as might beset it, with intent to accomplish its death, she is guilty of assault with intent to murder. And if the child die in consequence of such exposure, the mother is guilty of murder.